Delivery of judgment. Item 1, WPC 943/19.
The challenge to the impugned opinion fails and resultantly this writ petition is dismissed.
May I please develop? My lord, I beg to mention item number 58.
Yes.
My lord, just with accommodation, request.
This one 8, 12, 2025. I speak for Bailan.
Right.
May I please, your lordship, my lord? My lord, I have fair in item 47, my lord. That is, my lord, yesterday's first item, my lord. Lordship will be pleased to, my lord, upgrade this item, my lord. May be taken up after motion, my lord. 47. 47, my lord. Supplementary admission, my lord. My lord. Deeply applied.
Second question from the all side, my lord. I may be allowed to go file a PDP after 3 p.m. I am mentioning on behalf of S. Madam.
You want to file? Why do you want an adjournment?
I will affidavit, madam.
File an affidavit.
Yes, madam.
In a writ appeal?
Yes, madam.
Why is it necessary?
That I am mentioning on behalf of S. Madam.
Achha.
Due to
We are merely adjourning it. We are merely adjourning it. In an appeal, we don't require a affidavit unless something which is not in the writ petition has been urged. Okay, both sides are represented on the prayer made on behalf of respondent number 4. The matter stands adjourned today. List on when?
after 2 minutes.
After 2 weeks, it goes beyond vacation. Okay, list on 7/1/2026. Yes.
May I please, your lordship. Mr. I beg to mention item number 11, lordship. In this case, lordship, TCR was called for, my lord. Same was not received, my lord. So, my lord, it will come after 2 weeks, my lord.
11 LCR was called for.
Yes, lordship, earlier.
Okay, just wait till the matter is called. We'll pass orders.
Lordship.
Lordship, I pray for listing in motion for the motion.
Listing, give it to the court master. Give it to the court master.
May please, your lordship. Lordship, I beg to mention item number 29.
Yes.
Lordship, engaged counsel PS has some personal requirements after 1 week, lordship.
List on 8/12/25 as paid for by land counsel for the petitioner. Okay.
8/12.
Consider the article of petition item 30 lot. Conducting business that expired on 29 November.
It is expired. I'm so sorry. What had happened to him? I'm so sorry. I'm so sorry. Please convey my condolences, the condolences of this bench. Okay. After 2 weeks, then? After vacation? Okay. Both sides are represented. Court is informed that Mr. B. Pushilal, from our learned counsel, was holding the brief for the petitioner has expired. Mr. Expired, matter stands adjourned today. List after ensuing winter vacation on a date to be fixed by the registry.
May it please your lordship. Lordship, I beg to mention item number 3 for adjournment. Yesterday I was circulated the
Item number,
3 lordship.
okay. When do you want?
Any date lordship after vacation.
After vacation?
Yes, sir. In the first week of January.
Seventh of January.
Lordship. Deeply obliged.
May I, yes, I want to mention item number 4 and 5, pass upon the matter of
2 and 5,
4 and 5,
4 and 5.
pass upon the matter.
Just wait for some time, let the matter be called.
Okay.
Daily list item 1 for motion.
I on behalf of Mr. S. A. Ahmed, the matter may be accepted for order.
Let's come on.
He is out of it.
On the prayer made by learned counsel for the petition. Both sides are represented on the prayer made by learned counsel for the petitioner. List on 10, 12, 2025.
Item 2.
Same order. Same order on 10th January, 10th December. Item 2. Same order as item number 1. Okay. All these matters are coming up for the first time after 2019.
Please stop. Has lordship adjourned item 2?
Yes, same date, 10,
Yeah.
10th of,
The next date has been fixed, lordship,
10th of December.
10.
No. 10th.
Item 4 with 5.
Where is the ready?
4 with 5.
Yeah. Yeah, yeah. order আছে sign করা হবে আমি কিছু তাহলে কি করতে পারি Here there is nine. First date we say. Yes, we'll take it up after some time. We'll have to make an inquiry. What has happened here is that according to the record, the matter was first listed for motion on 24/5/2019. What is there in your record? In your record, what is the last date of?
Record, I
thing?
do not have, item 4 is not with me. Item 5 is there, but, not a single date has been mentioned, your lordship.
It's not there.
No, nothing, lordship. It's just 3/12. Today's date is there.
আছে আচ্ছা Yes, now I remember what has happened. 24/4/2019 was the first date when we were listed. The matter was adjourned. It came on board again on 24/5/2019. There's an order that the petitioner Bhanu Biswas
First, lordship.
has expired. 2590. So there is no substitution till now. So this is awaited.
I asked your lordship, she said Mr. Bhowmick is very sick, so
I understand, but technically it is, we have to adjourn, but we have to make a mention that this is otherwise awaited.
yes, lordship.
Now, the second case is Deepak.
And
Biswas.
it's Deepak Biswas, alias as Maran Biswas. You write separate orders, huh? Don't write a common order. In 2596, item 4. See, right? Both sides are represented. It have Lordship, Deepak Biswas, this next item, lordship. Item 5, Deepak Biswas is the son of Bhanu Biswas. So father and son are both before this court. Father is expired. And because in the next petition, lordship, it says Deepak Biswas, son of
no,
Shri.
whatever we are not
Biswas.
discussing any matter. We
Yes,
are not
lordship.
closing any matter. It was just recording because of the fact that we have to read the file, otherwise it takes a lot of time.
And lordship
Now
can
it
take
took
it.
5 minutes time to see what has happened.
Yes, lordship.
When,
Hmm?
matter was previous, both sides are represented.
After,
The matter was previously listed on
Lordship,
24/5/2019, and on the said date, the court had recorded that the petitioner Bhanu Biswas had expired on 25/2019. Till date, no application for substitution has been filed. Next para. On the prayer made by Miss, your name?
Tell your name.
Binita Singh Chaudhary.
Speak loudly.
Lordship, actually, I am Binita Singh Chaudhary on,
Wait, you make, tell your name first.
okay, Lordship.
Tell your name.
My name is Binita Singh Chaudhary.
Vinita Singh Chaudhary.
Sinha,
Sinha Chaudhary.
Singha Chaudhary.
Appearing on behalf of
On behalf of
the learned counsel for the petitioner on record,
TP Biswas.
placed for an adjournment. The matter stands adjourned today, list on 10/12/2025. In the next item, 2590. So both sides are represented. The records of the tribunal, comma, as requisition, comma, is received. Next, on the prayer made by Ms. So-and-so, behalf of the learned counsel of the petitioner on record. Place for adjournment, there is allowed, list on 10/12/2025.
Item 6 for motion.
10, 12 or fixed project, but I told you to take more time, you didn't tell so so now you fix the matter, then come on 10, 12.
Thank you, Lordship.
Then
No representation from the petitioner on call. Petitioner had remained absent when the matter was previously called on. Previously listed and called on 28/6/2019. All the respondents are represented. For enter justice, the matter stands adjourned today. List again on 10/12/2025. It's made clear that if the petitioner remains unrepresented on the next date of listing, my adverse orders will follow.
Item 7 for motion.
Lordship may be taken after 2 weeks, Lordship. Lordship it may be taken after 2 weeks, Lordship, although my senior is there, but he's not ready, Lordship. Lordship.
Item 8.
May I please, your Lordship?
কেবল সম্ভাব্য টেকনিক্যাল কি
आरो कभी सिंगल
On 25/5/2025, the petitioner mother was arrested by the border police of Surikhatar police station. Thereafter, took her to Matia detention camps. As told by the border police, the petitioner along with her family member visited the Matia detention camp, but got no information where about her mother.
They visited, what happened? After they visited, what happened?
Got no information where about her mother.
And find out the whereabouts.
Lordship, since it's not in the statement is not, she's not in Matia. So maybe with the BSF, Mr. Adhikari will give the instructions. Okay.
This is that, what do you call it? Information of
I hope
whereabouts.
his statement is correct because he says she was taken in detention in the month of May, Lordship, and we're in December now.
It's okay, maybe there are some reasons we don't know. Maybe probably, maybe some other reasons.
I get it from our
Ah.
department. Let Mr. Adhikari get it from the border security force, Lordship.
And Mr. F.A. Ahmed and
Copy the other.
Krishna, I think also for the respondents. Next. It is projected in this writ petition filed in Article 226 of the Constitution of India that pursuant to opinion dated 3/8/2017, passed by so-and-so, page 19, the said proceedee, who is the mother of the petitioner,
8, 9, 10, copy the other.
was taken into custody on 25/5/2025. And since then, her whereabouts is unknown. It is submitted that the petitioner made an inquiry with the transit camp at Matia, Gwalpara on 27/5/2025, but her whereabouts were not known. Next, accordingly, we request the learned CGC and the learned standing council for the FT and border matters to obtain information from the concerned authorities regarding the whereabouts of Srimati, not Srimati, it is Musammad, MUSSTT, Halima Begum, daughter of Mohammed Hassan, HASEN, Hassan Ali, wife of Mohammed MD, Mohammed Qasim, KESEM, Qasim Ali. The proceedee in case number so and so. And to inform the court about the same. Next para, based on 8/12. Next, before that, you say that the learned CGC as well as the learned standing council for the FT matters shall send a downloaded copy of this order to the concerned authorities to enable them to obtain information. You may be asked to furnish a
Copies.
This soft copy, read petition and soft copy, extra copies.
Lordship, he hasn't served a copy to me also.
Okay. By today, you serve them hard copy and also soft copies, because they'll have to transmit it to get the information. Make a soft copy and give it today,
Yes.
in course of the day.
For motion, item 9.
My pleasure, Lordship.
Yes.
Lordship.
Here also.
Lordship, here is the, actually, this petition is invoked actually. Lordship actually invoking the jurisdiction of habeas corpus as it reflects. The petitioner is a son. His parents have been made captive by some authority and has been made captive there at Saraikola, Pukrajar. That has been made known some other way he collected. And also came to know that he was tainted with foreign elements, and the foreigners tribunal, Jorhat, has also passed certain orders against him. All these are at the back without his knowledge. No notice were issued at a point of time. Now, son is actually like he is trying from pillar to post, but not been able to ascertain where the father is been made captive. In the meantime, some person, actually Golaghat, Gwalpara, has said that he might be kept at Saraikola, Pukrajar, a temporary camp, and he may go there. But he attempted to meet their parents, but he was not allowed to meet them. Now, Lord Imams, I actually pray before your Lordship, I have come invoking jurisdiction, that I am to be given the Okalatama by my parents where they are captive, and some authority to sign there that in the Okalatama that has been issued, that has been signed by my parents. They are just verifying this. So this problem has created me actually baffled where I should go. So invoking this jurisdiction under 226, actually, I have actually approached the Honorable High Court, and I pray before your Lordship that I should be allowed to meet my parents, and also at the same time, the parents are to sign the Okalatama for legal to ascertain the legal position in future in the judicial court. And that authority may not actually disturb me by no way. They are not to allow to meet my parents, Lordship. I can actually get the Okalatama signed for my parents, and also I invoke the jurisdiction again the lawful court for their rescue from the real terms of law. And in the way they have been made captive, they are in difficulties. And that's right, actually, this jurisdiction of the Honorable High Court under 226, I have come up with. The page was actually the page 10, where I have
First, get the information as to whether they are there, where they are presently.
We'll get the information.
Because they
Lordship.
were taken into custody
On May, Lordship.
May 2025.
Yes, Lordship,
We First, get the
20.
information, then we'll give pass orders for visitation.
Visitation.
take draft. That's
Say, Mohammed. Yes, first opinion against mother. Mother name is Musammat Dilwara Khatun, DILWARA Khatun, KHATOON. Opinion is at page 29. And father is Muhammad MD, Muhammad Asiruddin, ASIRUDDIN, page 32. Say, Mr. S. Sudhar and the counsel for the petitioner. Your name?
And Hawk.
Mr. Hawk, by course of day to day,
Lordship.
give to the CGC and to Ms. Verma a soft copy of this writ petition as well as a hard copy
Lordship.
in course of the day.
Lord.
We are issuing orders for informing the court about the whereabouts. On the next date, we will pass orders for visitation.
Got it, sir.
We are fixing the matter on 8 December 2025. Same order.
I looked up.
Item 10.
May I please, your lordship?
8-9.
Record paper and.
There is 7 cases there. Seven at John. Okay. 8.
Copy डिपोटी copy हमारे paper ध्यान है.
Yes, item 10.
Same order, Lordship will get the instructions. We'll get the instructions about the whereabouts of the petitioner, Lordship.
Okay. Opinion or in respect of who is, what is your relationship with the proceedee?
Son,
Son. Mother's name is Musammad, MUSST, Nasima, NASIM, Begum. Page 18. Same regarding whereabouts. Beginning to custody on 25/5/2025. What the same? Okay.
This petition filed with the.
Same order. In course of the day, give them copies.
Item 11.
May I please, your lordship?
Just a moment. Yes, Mr. Ahmed. I hope this today will be the last date when you don't serve copies on the FT matters, to the standing counsel for the FT matters. We'll adjourn it for a week. We will not give you indulgence. You are not serving copies to them. Even in this case, you have not served copies. What is the fun in not serving copies?
They make us parties, Lordship, but they do not serve us copies in all the habeas corpus.
You want us to adjourn
Yeah,
both
I'll
of your
give-
matters?
I'll give today, my lord.
But why advance copy was not given? Why did you try to save money? Today is the last day. If any other matter comes where you have not served copy, advance copies, matters will be adjourned for 1 or 2 weeks. We will not take up motion matters of yours. Don't do that ever. Oh. This is not the good practice. You don't give them copies and you want information. Why will they give you information? You don't know our rules. Today is your first day of practice in this court. Without knowing the High Court rules, you have started your practice. One case I can understand, there can be a mistake. This is the second case. We have to check from the records. You have not set copies. Don't repeat that practice. We'll not do anything. We'll just adjourn it and impose cost on you, not to be recovered from your client and paid. Don't do that. Check up all the records. If any other matter comes to in board where you have not served copies, we will take a very strict action. Yes, Mr. Ahmed. Mr. Hakim Ahmed. Yes, Mr. Hassan.
Meeting is noted. Maybe, inspection annually.
Yes,
Yes,
Your Honor,
Lordship.
they have received requisition and they have not sent.
Lordship may send a reminder, Lordship.
Hmm?
Just a reminder, Lordship, then we'll also pursue. It is, which tribunal is it? Borpeta.
Barpata.
Yes.
Lordship, maybe some miscommunication. If Lordship just gives a reminder, we'll also follow it up, Lordship.
Both sides are represented
Item 11.
by order dated 1/11/2025, the PCR of the concerned foreigners tribunal was called for as per office note dated 7/11/2025. The requisition was sent by speed post as well as by email.
Okay.
However, till date, the TCR is not received. Next, para, the registry shall send a reminder for the TCR. Next, para, the learned member, foreigners tribunal number first, Borpeta, shall take notice that in the event the records are not transmitted, if either physical records or scanned copy of the records are not transmitted by the next date of listing, or the court will be compelled to call for the personal appearance of the superintendent of the said learned tribunal. Next matter. As a matter of abundant caution, we also request the learned standing counsel for the FTN border matters to transmit a copy of this order to the Home Department, Home and Political within the Department, to follow it up. Next para, list on. Because he's also paying for bail.
Yes, madam.
That's the difficulty. List on 15/12/2025. Consideration of the prayer for bail. You know,
Lordship, we're just trying to find out.
no, it's okay. There's also a serious issue to be flagged. I am told, so far as Barpeta is concerned, the expenditure made for sending copies, because somebody has to come and give it. Those expenditures are not being reimbursed. And therefore, the tribunals, this DATA, those things are not given. At times, the tribunal has to spend money from their own pocket and give it. You don't have scanners. The SP Borpeta is not cooperating with for the scanning of the records and to send it. This is a real-time information I'm giving it to you.
Take it up with the department, Lordship.
It's a real-time information. Okay.
Obliged.
Item 12 or motion.
Have you served copies?
I have a copy, Lordship.
You should not have, because there is no acknowledgement here of service of interlocutory application to you.
No. In this matter, Lordship,
Yes, in WPC,
yes, we don't
there's
have,
an IA.
yeah, we don't have IA, Lordship.
Then, since both sides are represented, since copies of the interlocutory application has not been served on the learned CGC and the learned departmental council, the matter stands adjourned today, list after a week.
Obliged.
Better check it out. You will be in difficulty.
Item 13 for motion.
May it please your lordship.
Yes.
Lordship. Opinion dated is 38/2025, page 29, lordship.
29.
Yes, lordship.
Uh, But we are giving bill to us in
Yes, Lord.
time. But Mr.
A.K.
S.K. Chakma and
A.K. Hajong, lordship.
A.K. Hajong, I'm sorry. I don't know why I mix up with names. I'm sorry. A.K. Hajong, then counsel for the petitioner. And so for the respondents. Next,
Lordship, for respondent for G Sharma would be appearing, Lordship.
for
This NRC state coordinator, Mr. Sharma would be appearing, and for the other state respondents, 2, 6 and 7, I would be appearing.
you also add the name of Mr. G. Sharma. No? For the NRC. In that, in the list of names, add Mr. G. Sharma for NRC.
NRC is the.
Opinion is at page 29, dated 30/8/2025, asked by Spencer and Spencer. They were declaring the petitioner to be a foreigner post 25 Jan 1971 scheme. Notice extra copies within 2 days, call for the relevant records through email from the concerned tribunal. The prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in this literature, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border. Yes,
SP Gwalpara, lordship.
Border Gwalpara. List after 4 weeks on waiting receipt of records. Notice 4 weeks.
Deeply obliged.
Item 14.
Yes.
Lordship, impugn order page 95.
95.
95.
It is Hussain and counsel for the petitioner. Same order. Page 95 is the opinion dated 28/8/2025, asked by so and so. Declaring the petitioner to be a foreigner of post 25 in 1961. 10 days time to take bail of 5,000. List after 4 weeks on receipt of the records.
SP Kamrup,
SP.
Guwahati.
DCP.
Deputy Commissioner of Police, Kamrup. Metro Guwahati.
Item 15.
May please, your lordship, my lord. The input of order is at page 28. My lord, here in this case, my lord, initially the case was against 3%. Hussain Ali is my brother, Sushila Khatun and Mohammad Abdul Hussain. Abdul Hussain is myself, my lord. My lord, since the inquiry was only against Hussain Ali, the declaration was only given only against Hussain Ali. My name, my wife name has been dropped, but because of this order, I am also, my lord, now police is searching me.
I didn't get it. Please repeat again.
My lord, the case is initially against 3%,
Yes.
but the learned tribunal on records found that the case was registered pursuant to inquiry against Hussain Ali, only against Hussain Ali. Inquiry was only against Hussain Ali. So in following the Sudhir Roy case, my name, my wife name has been dropped, but Hussain Ali has been declared foreigner. Now the police is searching me. That is my problem, my lord. And other point is that there is another case previously decided where entire family has been declared not foreigner. That is Annexer 3, page 24.
Mr. Sigdar,
My lord.
you see, once you are not not declared to be a foreigner, so far as your challenge is concerned, which is to the opinion dated 25/6/2025, would not be maintainable. Your only anxiety is that the police is searching for you.
My lord.
So for that, we can have instructions received, and we can have you protected. So we convert this by a judicial order.
My lord.
We say that the challenge is not maintainable, but if you have
Police action, my lord.
apprehension of arrest by the police,
My lord.
we take up that issue
My
separately.
lord. My lord.
Yes,
Yes, lordship.
but Mr. A.R. Sigdar and the counsel for the petitioner and also for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated page 28, 25/6/2025, passed by so and so in so and so. They were declaring Muhammad Hussain Ali, MD, Hussain HUSSAIN Ali, son of Muhammad MD, Rohit, RUHIT, Rohit Mia, to have illegally entered into India within bracket Assam after 1971. This is ex parte opinion, huh? Ex parte opinion. Puspa. Puspa, it is further projected that the petitioner Abdul Hussain was arrayed as respondent number 3 as the opposite party number 3 in the said proceedings. However, in the final opinion, his name was dropped as the inquiry by the border police was limited to Mohammad Hussain Ali. In view of the said factual position, where though the petitioner was a proceedee, but the opinion was not rendered against him. The court is of the considered opinion that the challenge in the present form with the prayer for asserting the impugned opinion would not be maintainable. Next para, however, as the learned counsel for the petitioner has expressed apprehension that pursuant to the said opinion, the border police is searching for him, the court proposes to inquire into that aspect of the matter. Next para, accordingly, we direct the learned counsel for the petitioner to provide a soft copy of this writ petition to the learned standing counsel for the border FT and border matters in course of the day. Next para, the learned standing counsel for the border FT matters shall make inquiry with the concerned authorities in the Home and Political within bracket B department, as well as the Superintendent of Police within bracket border. As to whether the petitioner, namely Abdul Hussain, was arraigned as opposite party number 3 in the proceedings of FT case number 10 of 2015, decided by the opinion dated 25/6/2025, passed by the member, foreigners tribunal number 4th, Morigaon, is required by the border police for any reason. Next, the learned standing counsel for the border and FT matters shall transmit a downloaded copy of this order to the concerned authorities to obtain information. Next, list on same Monday,
Yes, Lordship, 8/12,
8/12/2025.
Well,
a soft copy.
we'll serve, my lord.
Yes.
By tomorrow, today is not possible. We'll serve soft copy by tomorrow.
Tomorrow.
Huh?
Okay. By soft copy by tomorrow. Next working day.
Lordship, all the instructions which we have to receive, the order copies may be furnished. Maybe uploaded, Lordship will take it out.
Just tell the court.
We have about 5 of them today.
Item 16.
Would any matter be possible for the time being? Or
Just-
does it, or maybe taken with item number 44, this item that my senior is in code number 15.
Okay, timing.
Item 17. Item 17.
Opinion is at page 22. I think this will be time.
I have seen the opinion, Lordship, Lordship, the IMDT references of 2004, Lordship. They appeared only once and after that never appeared. And Lordship
still,
will come to
uh,
page 23.
27, 325 opinion.
Yes, Lordship. Lordship can,
Same thing. None appears on call for the petition. The challenge is at page 22. Opinion dated 27, 3, 2025. Passed by so and so in FT case number so and so, IMDT reference number so and so. If I declaring the petition to be a foreigner or post. Ex parte opinion, huh? If I declaring the petition to be a foreigner or post 25 1971 steel. Notice extra copies, notice written within 4 weeks, extra copies within 2 days. Call for the records. From the consent tribunal by email at the following address. The prayer for bail is opposed by the learned standing counsel for the FT matters on the ground that despite due service of notice, the petitioner did not contest the proceedings and the learned and her learned counsel withdrew his wakalatama, and therefore, owing to the conduct of the petitioner, the prayer for bail is opposed. Considering the position, 10 days time to take bail out of this 5,000 to the satisfaction of SP border Gwalpara. You have come, okay.
Yes.
Mr. A.K. Ajam and counsel for the petitioner. List of votes on received records.
W.
Item 18.
Mr. Ajam, just a moment, if you have come.
Lordship.
What is the explanation of the delay?
Lordship.
And not non-appearance before the tribunal, what have you said? In fact, there's no explanation.
Yes, Lordship.
You are tendering apology before us.
Lordship.
Doesn't help you anyway. There's no explanation at all why you did not appear and contest the proceedings, despite so much of time being granted. You can thank your stars you were not there. The motion column.
Actually, I was in another court, Lordship.
May I please, your lordship, expertise judgment.
Some copies. Just give the
Ex parte judgment of 30/4/2009 lordship.
My lord, notices were returned answer. Page number 33.
It is there.
Page number?
33.
What is your explanation of not being present at the place?
My lord,
What is your explanation of not being there at the place when the notices were hanged at your last known residence? Yes. What is your explanation about the non-availability at the place when notice was served? There's no explanation of 35F. There's no explanation to your, in your petition. Yes, you must assist us. You must assist us. When you're asking your question, you must assist us. By not assisting, you have made me read all 19 pages of your writ petition. Yes. You are making us run out of patience. Yes.
ঠিক আছে আপনি বুঝি পান বসে আপনি ক কাগজ ফুট আসলে বাইরে ফুটে যাও Yes. Inquiry for Investigating agency.
With John, if you find out, at least in these 19 pages we have read, we have not found any explanation to cover up this 3(5)(f).
Lordship, 5A also, Lordship. If I may just read 5A, Lordship. The notice shall be served at the address where the proceedee last resided or reportedly resides or works for gain. And in case of change of place of residence, which had been duly intimated in writing to the investigating agency by the alleged person, it shall be served at such change address by the foreigners tribunal.
So
Lordship,
that means F will come, A doesn't come. F will come.
F will also come, Lordship. Maybe he was at work in Jorhat and his inquiry was done that the reference has been done in Jorhat. But he has never intimated the
That's
investigating
okay, we give him
agency.
an opportunity. Let him find out. You see, law is only a phase before us. We have to see the people who are not before us. Otherwise, there will be not, it will not be a dispensation of justice if you don't give an opportunity.
My lord, petitioner was going to Jorhat. He was work at Babul Borela house.
But what is your explanation? Why you did not inform the authorities? Why did you leave residence? It's not there.
No idea, no idea.
You see, out of so many things, we are asking only one question for which you are not responding. We could have dismissed it, but ultimately it is the proceedee who faces the consequences. Because of your inability to answer, they may not suffer. Mr. F.A. Ahmed, and counsel for the petitioner, and counsel for the respondents. The learned counsel for the petitioner could not respond to the court query as to why why the petitioner could not be found at the last address on which where he resided and worked, which is the registered address of the petitioner, and wherein notice was duly served. In compliance with the provisions of section 3, order 3 within bracket 5 within bracket F of the foreigners within bracket tribunals bracket order 1960. Accordingly, the matter is adjourned to enable the learned counsel for the petitioner to respond to the court query list on 8/12/2025.
Bless.
Item 19 for motion.
May I please, your lordship? Lordship. Impugned opinion is at page 58, my lord, annex N. which is put under challenge in this petition, my lord. Opinion was passed on 29th of January 25, my lord.
But Mr.
You does.
Also for the respondents. 14 is at page 58. 29 January 2025. Passed by so-and-so in the case number so-and-so, reference INDT case number so-and-so. Thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. Notice returnable in 4 weeks, call for the referral. Extra copies within 2 days, call for the record. The following email address of the learned tribunal. Prayer for bail is opposed by the learned standing counsel for the matter. Considering the objection, 10 days time, bail of rupees 5,000 to the satisfaction of Superintendent of Police border.
Gwalpara, SP Gwalpara, my lord.
List of offense.
All right.
Time being item 16 for motion.
Yes, my lord, the opposite party is the petitioner's father, my lord, was arrested, my lord. He is in Kukraza detention camp, my lord. My lord, earlier also he was arrested and he remained in jail, my lord, for 2 years, my lord. Thereafter, he was released, my lord. Presently, he is in Kukraza detention camp, my lord. The impugn order, page number 45.
In this form, your petition would not be maintainable. You are challenging the opinion. You cannot challenge your father's opinion.
Second.
Actually, my lord,
Father has never complained. He went to, he was taken into custody twice. He never complains.
my lord,
How
actually,
can you
the
challenge his
the
opinion?
present petitioner being the son, my lord, visited the,
Can't challenge.
my lord.
We close this matter with liberty. If your father wants to challenge it, you can maintain a challenge.
The problem was
Don't
that
maintain a challenge.
the petitioner went to Kukraza detention camp to get the signature in the Vokolatnama on behalf of his father. My lord, that was not allowed, my lord. He could not
Definitely.
detain, my lord.
Definitely. You see, forget about this part of the country. What has happened in
My lord, I have seen, but my lord, only signature is required. My lord, that signature I could not obtain, my lord. That is, I could not meet, my lord. I did not wanted to meet, my lord. Only signature is required, but it was not allowed, my lord. My lord, that may be observed, my lord. I will file again, my lord. That may be observed. My lord, I will, yes. My lord, as your lordship, my lord, I may get the signature, that observation may be made. My lord, I may be allowed to amend, my lord. Malu.
Just prove it.
On my lord, 25/5/2025. Kokraza detention camp. My lord, same prayer, my lord, item 44, son is the petitioner. So, my lord, same order maybe. Item 44, supplementary motion, my lord. Tribunal is also same, my lord.
Opinion at page,
Opinion page, my lord, page 41, my lord.
same order, page 41. You did it 23/2/2018.
Date of arrest also same, my lord.
Date of arrest is also same. Okay, we allow the prayer.
Oblige, lord, sir.
We'll take a short break and come back.
Supplementary item 42 for motion.
Yes. Opinion. Which page is the opinion?
Oh, government of this, no?
Lordship copy has not been served.
A copy is served on the government mailer to my.
No, this doesn't, you know, who are the.
Today
custodian
itself,
officers, you have
I
letters
will
from
serve
them.
the copy mailer.
Huh?
Today I will serve the copy mailer.
Then we take it up on Monday. Monday or Friday?
Lordship.
Okay, make it Friday if you are serving copy today.
agitated.
Based on five, both sides are represented. The learned counsel for the petitioner shall serve a copy of the writ petition to the standing council, learned standing council for the border and FT matters. List on 5/12/2025.
I'm sure our name is shown in the. Five, Lordship.
Friday.
Item 43.
একটু কাছে তো না? আমি appeal lordship.
Yes.
In this case, Miller, petitioner brother adduce evidence whose name appear along with
Which page is the opinion?
opinion is page Miller.
48 Lordship.
22 opinion.
Yes, Miller. What
You have to wait
a
for
date
some
of
time for bail.
argument is Miller.
You have to wait for some
Yeah.
time for bail.
Some interim protection Miller.
Heard Mr. A.M. Ahmed, learned counsel for the petitioner and so and so for the respondents. Opinion is at page 48. You take the format from, you take the format of order from my secretary, motion matter, page 48. Opinion dated. I'll give the dictation. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has said the opinion dated, this is at page 48, dated 18/11/2022, passed by so-and-so in FT case number so-and-so, SP within bracket B, reference number so-and-so, thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. This I have. So-and-so, so-and-so. Issue notice, returnable on, give a date after 4 weeks, returnable on so-and-so. Requisite extra copies of the writ petition be served on the learned CGC State and Departmental Council within 2 days. Next paragraph. The registry shall also requisition the records of the records of the relevant case from the concerned tribunal by sending requisition through email at the following email address of the learned tribunal. Next paragraph, the prayer for bail shall be considered on receipt of tribunal's reports. Next paragraph, list on so-and-so. That email address, you will get it from the court master. They will give it to you.
Yes.
Item 45 for motion.
Lordship, there's a correction. In the synopsis, it says, it's written, the impugned order is dated 30/10/2025.
Yes.
But the impugned order is of 30/10/2020, Lordship. At page 57.
In our copy, they have corrected it.
That copy not correct.
You do the correction, okay. Where is the opinion?
Page 57 Miller.
Page
57.
57.
A date of argument is 26/12/2018 Miller. After 2 years Miller, impugned order was delivered.
And after 5 years, official copy obtained.
Yes. Concession lage gele.
But 2020 it is still more than 5 years now.
Certified copy obtained in 5 Lordship. This is forget to mention.
And what is the explanation?
Para 14 Miller. Page 15.
Page
15.
15. One five. Para 13.
14.
14. No, 14 is nothing.
Winners is.
Here in this case, my lord, financial crisis and suffers from various ailments and my lord, argument was completed on 2018, my lord. And Angus counsel informed about the outcome of the judgment and is waiting for them.
It was earlier in 2018.
Okay, we issue notice. But Mr. A.M. Ahmed and Council.
Maybe.
Now going to input your.
We say A.M. Ahmed and Council for the petitioner. And so for the respondents. the order will be same like earlier, so I'm only giving the relevant parts. Opinion dated 30/10/2020, passed page 57, passed by so-and-so in FT case number so-and-so, SP border reference number so-and-so. Thereby declaring the petitioner to be a foreigner of post 25 to 1971 stream. Keeping the issue, in view of the inordinate delay in making the challenge, comma, keeping the issue of maintainability open, comma, issue notice returnable on so-and-so, same date. Extra copies within two days. The prayer for bail shall be considered, call for the relevant records from the concerned tribunal by sending requisition to the following email address of the learned tribunal. Extra, the prayer for bail shall be considered on receipt of tribunal's records. List on so-and-so.
Complex.
46 for motion.
Yes.
May please lodge. Note the impugn
2019
order, my lord,
opinion.
page 112, my lord.
2019 opinion.
No. Subsequent, my lord, that case was remanded by the small court, my lord, and fresh order, my lord, page 112. The second round of litigation.
But look at your cost title page 1.
My lord,
Look at your cost title page 1.
page
1. 2019 is also impugned.
Page 2 also. Page 2 also.
not in the page, my lord, 2 also, my lord. We have challenged both the order, my lord.
You
Because
can challenge both the orders. That's why it will fail. In the earlier round of writ petition, the said order was, the matter was remanded back.
Lord,
How can you challenge that order?
my lord, the remand was made, my lord, only by putting to, my lord, documents, my lord. The
Whatever,
learned
but can
tribunal
you-
was
can you-
directed, my lord.
Can after the High Court accepted the challenge to the earlier order, you can make this second challenge.
Sure.
It has to be, on that ground alone, it has to be dismissed.
Lordship kindly see order of this on court, my lord.
No, whatever be the order,
Lord,
can you challenge the same order again?
No.
Your writ petition will go on that ground alone.
Because consequence will earlier consequence. Consequence will.
You either modify your prayer or you withdraw and file a fresh one.
Consequence.
I put a- And it. Lordship kindly see page 99, my lord.
99.
Lordship.
Yes.
Paragraph
Paragraph 10,
10, my lord.
it
Lord.
will prevail over 25/9/2019.
Lord.
But 2019 is not on
So-
board.
Lord,
If you challenge it again, then we'll have to reject your prayer.
Last page, last page.
no, no, no.
Last page. Before fittings of 19 will be followed. April.
And there is another point, my lord. On 119, my lord. Page 119, paragraph 34.
Yes.
Paragraph 34, my lord.
He has a point. He has a point. The tribunal unnecessarily dragged that 2019 again. Okay. Where is the earlier opinion? 2019 opinion, where is that?
My lord, 89, my lord, page 89.
Okay. Heard. Mr. R. Ali, learned counsel for the petitioner and so and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has sailed. Give within brackets number one, serial number one. Opinion dated 25/9/2019. This is page 89. Passed by so and so in FT case number so and so, arising out of IMDT case number so and so. In page 89, I have marked this. I've given tick mark. Here also is the number. Then give a semicolon and within bracket serial 2, number 2, opinion dated 14/10/2025 is page 112, passed by so and so in case number so and so, arising out of IMDT case number so and so, thereby declaring the petitioner to be a foreigner post 25 till 1971 stream and full stop. Next issue. Notice returnable in 4 weeks, extra copies within 2 days. The registry shall call for the records of the FT case number 351 of 2016 from the concerned tribunal by sending requisition by email to the following email address of the learned tribunal. The tribunal address the court master will give it to you. Tribunal address the court master will give it to you. Next paragraph. The prayer for bail is opposed by the learned standing counsel for the FT matters. Next paragraph. Considering the projection made in this writ petition, 10 days time is granted to the petitioner to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border.
Now, my lord, Bozali, my lord.
Bojali.
Okay.
Bojali. This format of the order, you take it from my state secretary. Next para, list out of 4 weeks.
Deeply applied.
Upgraded item 47 with 48 for admission.
May I please, Your Lordship, my lord. Yesterday, Lordship was pleased to, my lord, call for the, my lord, case records of WPC, my lord, 5498, my lord, of 2020, my lord. Whereby the, my lord, the mother of the petitioner, my lord, she is the proceeding, my lord, she had put to challenge the earlier, my lord, ex parte order, my lord. That is in that particular record, my lord.
47 to কোনো appear করবো, 48 to কোনো appear করবো।
এখানে সামান্য
আমার
97,
সেদিকে কিছু হবে।
97.
আচ্ছা।
Yeah, I will say that there is one thing that it will. The difficulty arose because the earlier version the language is somewhere else. It will.
Not in this case, madam, my submission will be, but because madam, the opinion is under challenge. That may be heard, madam, it may be decided fine. There is no point.
No, but she would be entitled to bail.
Yes, madam. And the question to planning. There was an observation. And it.
Not to report observation is there, madam. At that time, she was in jail. When the melody, there was an
He
order.
was taken into custody
Yes,
in May,
yes,
23rd of May.
yes.
Yes, my lord.
7 months have gone by. Please, sir.
Because the initial order was also, my lord, not to report. In the read petition 5498.
Yes.
At that time, she was in custody, madam.
Hmm?
While the read petition was moved, 5498, my lord, 2020, she was in custody, madam. And at that time, there was a direction that not to report. And subsequently, my lord, what conspires, my lord, that due to the direction of the Honorable Apex Court and this Honorable High Court, so after completing of 2 years, my lord, she was released. She was released. And this read petition, my lord, in earlier occasion, they have taken time. 5498, they have taken time to file some affidavit, my lord.
Additional affidavits.
Yes, that is not bad. And today also, my lord, the
It's not there.
representing, my lord,
Anyway,
petitioner representing
no
the
information. I'll inform them. my lord. At this stage, my lord, I'm playing before your lordship, my lord. Lordship will kindly consider that part, my lord. She may be released on bail, my lord. That part only. Otherwise, my lord,
Just a moment.
yes, my lord. My lord.
In this case, what has happened is the opinion says that your mother, she's your mother. Your mother resided in a house of one
Faziruddin.
Faziruddin
Faziruddin, yes.
Ahmed. Staying of your mother in that house is admitted in paragraph 5 of the present writ petition.
Yes, my lord.
Correct. Now, in the earlier writ petition, you have the copy of the earlier writ petition.
Somehow I found that, my lord.
Hmm?
I got the copy.
You got it. See paragraph 4.
Yes, my lord. Please read
Yes.
paragraph 4. Being a layman doesn't know the process of law and being ignorant of the facts decided not to appear before the
Decided
tribunal.
not to appear. So she took a conscious decision not to appear. So the ex parte opinion
Yes,
can't be set aside when you took a conscious decision of not contesting.
my lord, this has been wrongly, my lord, pleaded. my
We
lord.
don't know, but
My lord,
this is
the
there.
counsel is, my lord, someone else, my lord. Lordship will kindly consider that
We
part.
understand, but you see, that's why we are telling you.
Yes, my lord.
uh,
But the person is same, my lord. And what I'm praying before your lordship, my lord, this lady has already, my lord, was in detention for consecutively for 2 years, my lord. Lordship will
That
kindly
means
consider
once
that
you-
part, my lord.
Once you admitted that it was.
There was a
wrongful
specific
decision.
direction, my lord, not to deport her out of this country, my lord. Even then, my lord, she was
that protection
deported.
you will not
taken
get.
back again.
Because once we
My lord-
don't interfere with the opinion, that is a protection you can't get.
What I'm praying before your lordship, my lord, now, is that, my lord, lordship will kindly, my lord, consider the entire aspects of the matter, my lord. Lordship will
We have
kindly
seen
release
that,
this
that is
lady,
why
so
we
that
see.
she'll be able to contest the reference on merit after, my lord,
No.
setting
we-
aside this particular order, my lord,
no,
in the
we
earlier
tell you.
petition, my lord.
You see, this paragraph 4 has not come to the notice immediately. We did some exercise and therefore we know it. So once paragraph 4 is an admission that she took a decision not to contest, please tell us how will we interfere with the opinion?
But it has well, been stated also that, my lord, she was ignorant of the facts, decided not to appear, my lord.
But she took
was-
a decision. Ignorant of law is one
Ignorant
part.
of fact, my lord.
The ignorance of fact is another. But the fact is that she took a decision not to contest is an admission. And in the affidavit, is the affidavit available with you? In the affidavit, paragraph 4 is something which is sworn by matters of record.
Affidavit, my lord, filed by whom, my lord?
Affidavit by your mother?
Proceed. That is not with us. my lord.
Look at this.
Oh, it, that affidavit, please.
Matter of.
Paragraph 4 is matter of record.
Yes. I have seen that, but my lord, that has been wrongly advised and wrongly pleaded, my
We
lord.
can't do anything.
Because of that part, lordship will not, my lord, discard the
See.
entire facts and the scenario of the case, my lord. This is my
Mr.
humble prayer, my lord.
Please try to understand.
Yes,
We can't form an opinion that the petitioner has been wrongly advised. That is an opinion which we are not authorized to make because there is no material on record. And with this admission, your opinion, we were wanting a way out to see if you can get some relief. But once this paragraph 4 has come to a notice, the opinion will have to stand.
my lord, she has no way left out, my lord. If, my lord, she has to, my lord, contest the reference, my lord, on merit, my lord. And if she is not released on bail, my lord, she will not be able to contest the reference on merit, my lord. She'll be in
You see,
very difficult
this-
situation, my lord. And since she has already, my lord, was in detention for 2 years,
see,
my lord.
in a lighter note, I always make a statement
My lord.
that when I was ill, I went to a doctor. You have heard it 100 times, I think. I went to a doctor, doctor checked me up and then told me that, sir, you don't have a heart. So even the doctors don't find a heart inside me. What to do?
Lord, for that part, my lord, I offer my lord, my sincere apology, my lord, on
No,
behalf of the, my lord,
you
procedure.
see,
Otherwise, my lord,
you see,
on the basis of, my lord, materials, my lord, which have
you
been
see,
placed
we
before
don't-
your lordship, my lord. If we do not become, my lords, if we do not go, my lord, technically, my lord, otherwise she is ready
There's
to
no
contest the
material for
reference.
us. You see, technicalities is something which you are making in sufficient. But please tell us what is the material before us to form that opinion that or to accept your contention that the petitioner was wrongly advised. That is something which we can't draw inference.
My lord, this has been pleaded by the, my lord,
No,
some
even
counsel, my lord.
conduct, even.
This
in
may not be the
opinion, my
version of
lord.
the proceeding, my lord.
Conduct there in the opinion shows that.
My lord, with all respect, I am submitting, my
That is
lord.
one part. See, there may be many things.
Yes.
We're
Yes.
not on that. But once the petitioner makes an admission
Decision.
that I
That-
took a decision,
My lord, that part, my lord, I can assure before your lordship, my lord, that she has to contest the reference on merit, my lord. I am assuring before your lordship, my lord, being an engaged counsel, my lord.
In fact, he is not the
She
engaged
has-
counsel in that case,
first
my
you'll
lord.
have to overcome this.
No, you are not the engaged
Till
counsel.
till date, I am not the engaged counsel,
But
but
you'll have to first overcome paragraph 4.
my lord. But this is probably, my lord, what I have seen, my lord.
We were sincerely trying to find out ways to see if you can be released on bail. But with this admission, we are finding it very difficult.
This has been rendered wrongly drafted, my lord, probably, my lord. Otherwise, she cannot escape, my lord. She has to contest, my lord. But I am praying before your lordship, my lord, unless she is released on bail, my lord, she will not be able to contest the reference on merit properly, my lord. She will not
see-
get the proper chance to defend her side. my
See, we can't do anything. The reason is that we always very honorably add the word learned in front of the lawyers. Learned lawyer said that, learned so-and-so said that, learned counsel said that. So this word learned will remain with you. How can I arrive at a conclusion that the learned advocate was not learned? You can at best adjourn it, you find out ways and means, Friday we'll take it up again.
My lord.
Try to find out, you can have any answer. Because with this, even there are two judgments of Supreme Court that for the fault of the lawyer, one should not be put to difficulty.
Yes, my lord.
That also will not help you, because there's an admission. Still, we are giving you time to try to find it out.
My lord. My lord,
Your,
Friday.
Mr. Digari, your, this, instructions are with us only. Also, they represented. Pursuant to the order dated explanation. 2/12/2025, the records of WPC 5498 of 2020 has been tagged. Stop, next para. On a perusal of the said writ petition, comma, it appears that in paragraph 4 of the of WPC 5498 of 2020, comma, the petitioner has admitted that that being a layman, comma, she does not know the process of law and being ignorant of the facts, decided not to appear before the tribunal. As nothing adverse will happen if the petitioner does not appear before the tribunal. Next para, in view of the said admission, comma, it appears that the petitioner took a conscious decision not to contest the proceedings. To stop. On the said aspect being brought to the notice of the learned counsel for the petitioner, comma, he has submitted that he was not the counsel engaged in the earlier writ petition, and therefore he pays for some time to address the court.
Right.
Matter stands adjourned today, this on 12/22, fine.
Right. But can it be on 10th, my lord, if possible? 10th of, my lord, December, if possible, my lord.
When?
10th of December, my lord, if possible, my lord. I'll leave it to
Oh,
your
sorry,
lordship.
I'm wrong. In fact, Friday means 5th.
Fifth,
You
my lord,
wanted it
yes.
on 5th.
Yes.
You wanted on 5th or some other
Fifth, my
day?
lord.
5th. I'm sorry,
Right.
I was meaning 5th, but I said 12th. Okay, 5th.
Right. Deeply obliged.
Upgraded item 38 for orders.
May I please your lordship? Lordship, the assisting counsel, Mr. C. Chakravarti, he is not in a position to appear due to his father's medical emergency. And as such, the senior counsel is also not in a position to appear, Lordship. Lordship, after 3 weeks, Lordship.
Matter then. both sides are represented. The prayer made by Ms.
B Shah.
B. Shah, of appearing on behalf of the learned counsel for the petitioner on record, submits that the learned counsel for the petitioner is unable to appear before the court today. So accordingly, the matter stands adjourned. List after.
After vacation, Lordship, any date?
Give a date after vacation.
7th of January.
Lordship, there is an interim that may be continued.
Is the interim order? Okay.
Sorry, my lord, for coming this way, my lord. My lord, there is a urgent matter, my lord. It was actually listed before Honorable Court 2 today, but it could not be taken up due to, no, it was done not by me, my lord, due to conflict. My lord, it may kindly be taken up, my lord, DRT matter. Sorry.
Well, I'm sorry, Milord. Milord, what had happened, we have filed a petition, Milord, before the division bench because normally it goes. Honorable Justice Unnikrishnan Nair has some difficulty, Milord. Now, our problem is, Milord, against the order passed by the authority, we intend to file an appeal under section 17.
No, but you have to route it to the
Registry, Milord.
to the registry because it
Which
has to have the administrative approval of the Honorable Chief Justice
Of
to.
course, of course. That's why, Milord, since that honorable bench says that.
We understand.
We'll do
Not
that.
difficulty,
Milord.
but
Ah.
you'll have to route it through the registry.
Yes,
because
just now we'll do that, Milord.
the administrative-
Only thing is, Milord, there is no presiding officer.
No, that's okay.
Yes.
But administratively, it has
Yes,
to be
yes.
the Honorable
We-
Chief
it
Justice.
is, Register will be-
Production list
We were given to understand, Milord, if Lordship orders, of course, with the permission of the Honorable Chief Justice, then the permission can be given. Milord. Otherwise, Milord, they say,
already.
they went there. That is how we are mentioning before Lordship.
No other division.
Let me inquire. Give the
Yes.
case number to the court master.
Yes. We did, yeah. Deeply obliged, Milord.
Because you don't want to usurp the jurisdiction.
No, certainly.
Yes.
Upgraded item 40.
May Lordship. My lord, this I is filed for a consideration of the bail, my lord. Petitioner in custody, my lord, more than 6 months, my lord. And 27/5/2025, he was in custody.
You challenge the 2009 opinion now.
Yes, my lord, that expert opinion, my lord, and the petitioner is still in suffering, my lord, eye problem. He is unable to move, my lord. I annexed all the document, my lord. And without help of the others, my lord, he is unable to move, my lord. Various document I annexed, my lord, so expert opinion, my lord, case 11 to onward, my lord. Case 14 referred to the syllabus for the department.
And who is the petitioner?
Petition, I heard the petitioner is the wife, my lord. And applicant is the wife, my lord. And the petitioner is the husband, my lord.
No, this is signature of Mohammed Ukiluddin.
Ukiluddin is the husband, my lord. He affidavit is filed, my lord.
He's the husband.
Yes, my lord, he is the husband, my lord.
What is the disease?
Yeah, my lord, eye problem, mainly eye problem, my
So,
lord.
but which page will I find the nature of eye problem?
My lord, I studied para number 4 and 5, my lord. And all the document is eye problem. Another disease also, my lord, in the eye is the major problem, my lord. Eye status is unable to move also, my lord, without help of the others, my lord.
No, but in the medical document, there must be some disease referred.
Yes, my lord, this is the, my lord, the document, my lord, from the medical authority, from detention camp, my lord, we collect this document, my lord. From civil hospital, he was referred, my lord, and optical department, my lord. Various diseases, they are the main problem, serious problem is the eye problem, my lord.
So you see, because you see, Mr. Ali,
Yes, my lord.
please come to page 12. There's a provisional diagnosis. I can't read this.
Hmm.
This spelling I can't read.
Yes, my lord.
And to my limited understanding, there's no disease like that. It must be meaning something, but there is a spelling mistake. What is it? We don't know. That's number one. Second, you see, page 13,
Yes, my lord.
case history,
I know. 15, my lord.
one. What is this spelling? I don't know.
My lord. And
Correct.
this,
CAS or CAT, we don't know. Development.
yes, my lord.
Now-
17 also.
What is this CAS or something that we can't understand?
This taxation issued by the doctor, my lord. So
And
I am
the
also unable
second
to.
is against the same spelling CAS or something, calcinos. There's
Right.
nothing called calcinos in the medical term. It will be calcinosis, which is deposit of calcium. But we don't know, since I'm not a medical student, I don't know, but this is something I'm not aware of it.
As per my information, my lord, the husband in law, his eye or left hand, his too much problem and his, so he's unable to. And other disease also there, my lord. But Doctor Banan, I'm here to from. Doctor is playing, I'm here to from.
Let us see on merit what we have here.
But so one minute. No document was submitted, my lord.
No document.
No document, my lord. Only written statement was submitted, thereafter he was absent.
Because Mr. Sharma, the, when these people are present, who are in custody are presented before the doctors, there should be an SOP that they should write correctly. You see, if she's suffering from something and we are denying bail merely because we can't read it, that is also bad. And why can't the doctors write correctly the nature of disease? You see, if there is a spelling mistake, let us think of a situation where the learned counsel is filing a writ petition, writing that application under Article 226 of the Constitution. Constitution he can't spell correctly. He writes Constitution in a different spelling. What will you think of the counsel presenting the writ petition? Correct. Same thing is happening if the doctors write a prescription and then we can't read anything out of it. See, somebody is asking for bail on the ground of the disease.
I think Lordship, let me tell the instruction, Lordship.
And very strangely, you see, in one of the documents that page 13 or something, weight of the person is written as 25 kg. A 50-year-old adult cannot be of 25 kg. Adult can't be 25 kg.
Yes. Lordship, let me take the instruction, Lordship. What is actually happening, Lordship? And Lordship, otherwise on merit, Lordship may also.
No, not on
dispose of
otherwise,
matter,
because
Lordship, on merit,
if
Lordship.
somebody is having some ailment, we can't deny liberty merely because we can't read it. So please get the information.
Lord.
We'll take it up on Monday.
Lord.
You get sufficient time by then. And what is your explanation, Mr. Ali? Please tell us about the non-filing of the evidence and all. What is your explanation
Oh,
here?
my lord, regarding delay part, my lord.
Yes, that you did not
My lord-
contest the matter.
My lord,
What-
delay part, I studied in my read petition, my lord.
Yes, please tell us, show us that.
My lord, actually, in first he was present, my lord. Subsequently, some impression were taken by the council, and thereafter he may absent, my lord. And he was not communicated with the council, as well the council never communicated. That is my lord, we admitted, my lord. I not counsel anything, my lord, counsel anything, my lord. And document also, no, I have gone through the report, no document was, my lord, placed, my lord. Nothing, only written statement, my lord.
More than 15 years, Lordship, he never bothered about the case. Only after arrest, Lordship, he approached the police.
I admitted that part, my lord.
Mobile.
ঠিক আছে।
কি? Yes. Yes, Doctor, same. That matter. Yes, no.
My lord, at the time, no document was submitted, my lord. At the time of when the order was passed, my lord, no evidence was before the learned tribunal, my lord. And when, my lord, he was arrested, my lord, this document was collected, my lord. And he was also not aware of the judgment, my lord. That is, my lord. So, my lord, my humble submission, my lord, at this stage, my lord, the medical report, especially my eye problem part, my lord. And this, the coordinate with also, my lord, regarding the expiry order, my lord. Some cases are coordinate also consider, my lord. The long matter, pending matter, my lord. Today I not with that part, my lord. Only today after consider the bail part, my lord. And yes, my lord. Yes, my lord. Yes. Matia Malad. Hello, Blanche.
No SP concerned, no SP con, they will send it to transaction material.
Hello.
Upgraded item 41 for orders.
May I please your option? This is for correction, my lord. My lord, may kindly come to page 9, my lord. Last line, my lord. Registry to requisition the case record in respect of case number so and so 2519/2019. This should be 2017, my lord. Correction. It is 17. Yes, ma'am. In the next page, it is corrected, my lord. Okay. My lord. Yes, ma'am. Main case, my lord, the matter may be fixed for admission hearing, my lord. Eight 12, my lord. I am obliged. My lord, can it be on some other day? On 8, I will give 10, 10.
Upgraded item for orders, item 49.
May I please, Your Worship? My lord, the petitioner has been, my lord, arrested on 11/11/2025, and he is in, my lord, in the detention camp at Golpara, Matia. Now, Lordship kindly see, in the IA, my lord, page 11 is the order. that is impugned in the, my lord, present writ petition, page 11, my lord. Page 11. Now, my lord, operative part, lordship will find page 12. The, my lord, OP exhibited documents are as under. Exhibit 1 is the nature of certificate dated 13/7/2017. Found it is not duly proved, extant rejected. Exhibit 2 is a certificate of same nature. Found it is also not duly proved, rejected. Exhibit 3 is the bank passbook of Assam Gramin Vikas Bank in the name of the OP. It appears to be not relevant for the purpose of OP's case, discarded. Exhibit 4 is a voter list of 1985. It appears claimed name of the OP's father accepted. Exhibit 5 is another voter list of 1966, proved in original, and it appears to the claimed name as the OP's father accepted. Exhibit 6 is also voter list of 1970, proved in original. It appears same name as OP's father. Exhibit 7.1, Exhibit 7.2 is a PAN card in the name of the OP. After end of the perusal of the aforementioned documents, all it transferred that the linkage of the OP is not established with the claim it is his or father, OP is liable to be declared foreigner. Now, my lord, no discussion, no findings are specific, my lord. Yes. Now, lordship, kindly see Exhibit 5. Exhibit 5 is another voter extract of 1966 proved in original, and it appears the claim name of OP's father accepted. Now, since, my lord, fathers and daughters linked are established, my lord. Yes. Yes. My lord. Now, linkage, my lord, that was, my lord, the circle officer certificate was, my lord, that was rejected, but that was, my lord, exhibited.
But not proof, only.
Not proved, not proved. And that is there, my lord, that is there. Now, then now, my lord, present, my lord, situation, my lord, like that, my lord. Since she is in, my lord, custody, let the, my lord, writ petition be heard expeditiously, and in the meantime, my lord, she may not be, my lord, deported.
Yes.
My lord.
Developed lordship. Of lordship.
Production list, item 1. WPC 6876/25.
Made please. My lord, the petitioner says. No, I'll go very slow, my lord. Yes. My lord, the petitioner before lordship is one of the partner of this firm. The name of the firm is, my lord, Silverline Enterprise. It's a partnership firm of which the petitioner is one of the partner, and it owns a hotel, my lord. The hotel is by the name of Autumn Crocus. Lord, because of the recent construction of the flyover, we have given the photographs, my lord. Entire access to the hotel was stopped for more than 1 year. Now, of course, the flyover is completed. Now, my lord, there is a default. If a lordship would kindly come to page 56, and the operative portion is at page 57. As on date, my lord, 89,05,292 is due, my lord. At page number 57, my lord. The Bank of India, it's a statement. Silverline Enterprise, Hotel Imperial Plaza, GS Road. And the operative portion is at page 57. So the balance is today, as on date, is 89,05,292. Now, my lord, without serving any notice to the petitioner, now, my lord, without 13.2, 13.4, none of the notices were served. Now, apparently, my lord, symbolic possession has also been taken, and an impugn order was passed, my lord, at page number 45, whereby, my lord, the petitioner was directed to hand over possession of the property. At page 45. And the operative portion is at page 49. 47. Now kindly come to page 45, my lord. This is the order. I'm number 2, Malavika Rajbangshi. This is the final intimation cum notice for removal of movables and handover possession of the mortgage property sold under SARFAESI. I am, my lord, not only a partner, I am also one of the mortgager. Now, my lord, this is the notice. Now, my lord, I intend to assail this notice under section 17 of the DRT, my lord. Now, we are not in a position to, my lord, move the petition because till 14th, the, my lord, presiding officer is not present. If your lordship would kindly have my averments, my lord. Para 10. That is why I had to approach this honorable court. That being page 10, that being agreed by the impugned final intimation cum notice dated 28/11/25, along with all the steps taken by respondent bank, the petitioner herein wanted to challenge the same before the Honorable Debt Recovery Tribunal, Guwahati. However, currently the presiding officer is not available in the said DRT Guwahati till 14/2/25. As such, it is humbly submitted that operation of the impugned final intimation cum notice be stayed, otherwise same would cause prejudice to the petitioner, as she will be deprived to file an application under section 17 of the Act. Basically, this is why I'm before your lordship. Yes, my lord. Yes, my lord. Huh. Huh?
Not me.
But this was at the instance of other partner, my lord, not at my instance. Now, if your lordship would kindly have this Surface Act for a moment, I can do under the rules, my lord, under Rule 3(4), all borrowers are required to be served with notice, my lord. At least have the rules, my lord. Yes. Yes, my lord. The demand notice has been validly issued. An applicant, in spite of due receipt, did not exercise the right under 13(3)(a) of the, but this is by the other partner, my lord. Yes. Yes. No, my lord. Under this scheme, this is a special act. The procedure will perhaps prevail, my lord. If your lordship would kindly have the rules for a moment. Rule 3, my lord. Security Interest Enforcement Rule 2002. Rule 3, heading is demand notice. My lord will kindly come to Rule Sub-Rule 4. Where there are more than one borrower, the demand notice shall be served on each borrower. And my lord, under section 2, a borrower also includes, my lord, a guarantor. So that way also I am entitled to a notice. Well, end of the day, these are all procedural safeguards. So I would like to take this plea before the tribunal, my lord. Because presiding officer is not there, I am prevented. That's why I have come to your lordship, my lord. Lordship will give us time till 14th. Till 14, my lord. Thereafter, my lord, tribunal will take a call. Because I have my statutory remedy. And my lord will kindly see, they have fixed the reserve price also arbitrarily. The reserve price which they have fixed, that is arbitrary. If your lordship would kindly come to my lord, section 2F of the Securitization Act, my lord, in the definition portion, borrower has been defined. Yes. Yes. Therefore, my only submission is, my lord, I as one of the partner, one of the borrower, guarantor, I am also entitled to a notice. That in paragraph 17, my lord, I have categorically made that statement. Nothing has been done, my lord. Neither 13(2), neither 13(4). So my only humble submission is, my lord, status quo as on today be maintained, my lord, and I'll approach the tribunal on 14th. And whatever on merit tribunal decides, now will take its own course.
Not I appear on instructions, my lord. This petitioner is the wife of the applicant before the learned tribunal. That is there. Now, my lord, my further instruction is that the notification has already been issued. The learned DRT, presiding officer of DRT Siliguri will be sitting from tomorrow. As of yet, my lord, they have not filed any application under section 17. The previous application is pending, that is fixed on 15th. That notification I do not have at the moment. I have the instructions only, my lord, that the DRT Siliguri will be the link officer, because that is normally, my lord, that officer has been designated, that when the DRT presiding officer DRT Guwahati is there, then normally that is the course, and he is said to be sitting. Or lordship will take it up after some time. I will try to get.
My lord, if that be also so, at least some reasonable time so that I can approach them. Yes.
Good.
There, I will be. Okay, I, every day. Will be delivering custody. Perhaps the right not as. If that is.
Follow.
You are actually telling me this. Okay, I will.
Because actually the difficulty in the instant case is that post the order of the DRT, in fact, the order of the DRT, the interim order which has been placed by them, that order, my lords, on that very day, the auction was held. That was the second auction. And the matter is now confirmed.
No, well, at the end of the day, this sale has to be registered, sale deed has to be registered, these processes are there, I said. That's why I said, symbolic possession you're already having, that I'm not disputing. Only thing is, I must get an opportunity to redress my grievances. And then the forum is not available, where do I go, Millard?
Look.
Millard?
That is.
Daily list item 20 for admission.
No, Millard, the problem is Honorable Justice. Yes, that's why, Millard. Yes.
My apprenticeship. Against the that is annexure of two lordships, a judgment of the learned tribunal. Page 20. Yeah, he issued 31/5/2018 lordship. It is not an ex parte lordship. She appeared immediately after receiving notice from the learned tribunal and filed her written statement and adduced evidence before the learned tribunal lordship. Only on the basis she had exhibited 7 documents, lordship, but that could not be proved. Linkage is not proved with the father. May I read, Lordship, in my evidence, I have exhibited, Lordship, page 22. That is exhibit A is the certified copy of the voter list of 1966 of the village Rampara Nonke in the name of parents of the opposite party. B is the voter list of 1970 of the village Rampara Nonke in the name of parents of opposite party. C is the voter list of 1985 of village Rampara in the name of the opposite party and her husband. D is the certified copy of the voter list of 1997 of village Mamunpara in the name of opposite party and her husband. E is certified copy of the voter list of 2005 of village Mamunpara in the name of opposite party and her husband. Exhibit F is the school certificate of the opposite party issued on 11/11/93. G is the copy of the damage report of school issued by the in charge headmaster of the Rampara in the NC Girls School. It is in page 22, Lordship. Now the Lordship. The link. Yes, Lordship, that could not be because that petitioner had supplied all the copies of linkage documents to the to her council, Lordship, but that he did not submit that two linkage documents before the learned court below and applied her that it is not relevant for in this case because she has already submitted the voter list of 1966. She is the literate lady only read up to class 3, Lordship. Therefore, after passing of the judgment, Lordship, on 3/3/18, she, after obtaining the copy, certificate copy of the order, she submitted an review petition before the learned court below for producing the same, Lordship. That I have annexed in my petition at page Annexure 3, page 26, Lordship. But the learned
Page number?
26, Annexure 3, Lordship.
Yes,
Review
this
petition.
was rejected.
But the learned court below did not refuse to, refused to accept the review petition, Lordship. In this review petition, I was specifically mentioned about that linkage documents and about two linkage documents that is page 39, Lordship. It is the translated copy, main copy is page 40 of the Gambura, local Gambura from Rampara village, Palm. And second one is the linkage document of secretary to the Rampara Gaon Panchayat district, Barpeta, Lordship. He did not produce that document on the because his council failed to produce the same, Lordship, before the
Ms. Dev,
Lordship.
you see,
Lordship.
please tell us if we are wrong.
Yes.
In fact, under the Foreigners Tribunal's Order, 1964,
Yes, Lordship.
review is not permissible.
Review
By law,
order
is-
3A is permissible, Lordship.
Hmm?
3A of the order 64. That is a
Not 3A, 3C.
3A, Lordship.
Yes, new, nothing from
Huh?
active provision.
Human
3C, Lordship.
3C, not 3A.
Earlier it was 3A.
Probably.
Oh, no, that has been, this has been amended with effect from 2019.
19.
Yes, you just have this.
Not permissible, but Lordship in a power of foreigners tribunal, it is specifically mentioned about. Power
I
of
don't think
tribunal,
so.
that order 4, power of the foreigners tribunal, that it follows the civil procedure as well as the
That
criminal
doesn't have
procedure.
review. It
Lordship.
doesn't have review. There are several judgments which says review is a creature of statute. Power of review cannot be inferred.
In that case also, I have challenged everything, Lordship, before this honorable court.
No,
That,
that's okay. But since you said that the review application was not accepted,
because as per that 3A in the book
this
itself,
amendment, that's why we sent you.
etiquette হইছে। Etiquette
Mr. Sharma,
amendment
show it
হইছে।
here, huh?
No, no.
The
What is-
procedure for setting aside ex parte order.
Amended kitty হইছে।
19.
Amended with
Nine,
effect from
no,
2000.
my case is 18, Lordship. I have,
No, no,
my-
ঠিক কথা বলছি, তুমি কি আছে?
yeah, to.
Now, if her case is 2018, that the earlier will follow.
Yes,
Send it
Lordship.
back,
That is why.
send it back,
This is the 19.
send it back. Find it out.
After going through the honorable, dishonorable courts directed not to deport the petitioner from India, Lordship.
Send us your book.
Yes.
Same provisions are only earlier one.
So 3A is same as now
Yes,
3C,
yes, I've seen that.
same as 3C.
But second one, Lordship, that interpretation, last occasion I have argued before the another
No, it's okay.
honorable Lordship regarding that.
What is your submission? What
Three-
was your submission?
That is second one. First one, it is regarding the expertise order, 3A1. Second one, it is specifically mentioned about the all of the any decision passed by the court within 5 years. Why the two provision has been given
Please
in
read that.
3A?
Please read that.
First one is the where the foreigner tribunal has passed an ex parte order for non-appearance of the proceeding, and he or she has sufficient cause for
That
not.
is one. That is
Two
one.
ones.
Come
Your
to two.
lordship. Second one, the proceeding may file an application in the foreigners tribunal within 30 days to review the decision of the foreigners tribunal, claiming that she is not not a foreigner, and foreigners tribunal may review the decision within 30 days of the receipt of such application and decide the case on merit.
Yes, now you please see this page. Where is your statement regarding you went to the tribunal? Where is that?
Oh, lordship, I am. Page page 8, lordship, paragraph 12. Page 6.
Sharma,
Yes, lordship.
if power of review is there
Yes,
and
lordship.
she is approached within time, then the matter has to be sent back to the tribunal to decide this on merit. They can't
Yes,
approach it
lordship,
like
but
that.
lordship, my humble submission is that lordship, I think lordship, this is only in respect of ex parte order. Lordship, heading is procedure for setting aside ex parte order. Where the foreigners tribunal has passed an ex parte order for non-appearance of the proceeding and he or she has sufficient cause for not appearing before the foreigners tribunal. It may, on the application of the proceeding, if filed within 30 days of the said order, set aside each ex parte order and decide the case accordingly.
If one
Yeah.
is there, then why there's a
Second one.
application on number 2?
Yes,
Why there is a
lordship, the
replication?
proceeding may file an application to the foreigners tribunal within 30 days and to
review the
review the
decision.
decision of the foreigners tribunal. Decision, I think lordship, this is
I don't think.
because
statute- Once there's a statute, we go by the
lordship,
little interpretation.
yes, lordship, because I think lordship, this is continuation of
No,
Oh.
cannot be,
You
lordship.
see, there cannot be two provisions for review.
lordship.
One will say ex parte review, one will omit the word ex parte review.
Yes, lordship.
we have to give some meaning to the legislature.
Yes, Lordship. Lordship, kindly give me 2 days time, Lordship. I clarify myself, Lordship. These two things, Lordship.
Friday then.
Lordship.
এটা provision হ'ব পাৰে নেকি?
What's right represented on the prayer made by Sri G. Sharma and his standing counsel for the case of the matters. List on 5/12/2025.
Okay. That case was heard on at length, Lordship, last
Well, then,
occasion also, that point eroded before the.
Wals have ears, I follow that. If you tell anything to Wal, the Wal will tell it to me. So argument made before another bench, we understand.
No, just to same point.
No, we'll tell you what you argued.
Yes,
You want to know what you argued on that day before the other bench? You refer to the opinion, then you refer to the exhibits, same thing which you did today, and then you refer to the Gamura certificate. And then you refer to the application under this three.
Secretary of the.
That was not taken care of. And then then page 42, that disclaimer you rely on, and then electoral registration officer does not have jurisdiction, that was you said.
Yes, Lordship.
Correct.
Yes,
You said
Lordship.
it was mechanically forwarded, the reference was
Yes,
mechanically forwarded before the SP.
Yes, Lordship.
But don't worry, we know. He told you the Wals have ears.
Obliged, Lordship.
Production list item.
So the standing notification, Malad, there is standing notification, and I am instructed, Malad, that if they file, Malad, it will be placed before the learned from tomorrow onwards.
Milord, we have also checked up that Siliguri also PO is not there, Milord.
Serial number 12, Malad, in charge of the, whenever the PO is on leave, PO of Guwahati, Malad, we Siliguri takes over.
No, there's something wrong. There's something wrong.
Lordship.
You have a copy of this
Yes,
notification?
yes, I have.
Please read that first line. I am directed to inform all DRTs under jurisdiction of DRT Kolkata, advocates and litigants, that wherever any presiding officer of any DRT under the jurisdiction of DRT Kolkata is are on leave, the urgent work related to so and so. If the presiding officer is not there, it can't be said to be on leave.
He is on leave at the moment. At the moment, the PO of Guwahati is on leave. The presiding officer of Guwahati DRT is on leave. It's a standard practice. Let me just
The
clarify.
officer is there.
No, he is not there. He is
No,
not in
The
station.
officer is there, man in position is there, but he is absent on leave.
He is on leave. And he is on leave, Malad, as per my instruction till the 14th of December.
That's what we have stated in petition also.
Saying that only.
Well, first they have to file, then Malad, it will be listed on the basis of urgency. And that is also indicated in the paragraphs 2 and 3. Malad.
Notification of तारीख कितना?
19th of February.
देखो ना, मैं सोमवार फाइल करूँ. Till it is taken up, status code. My lord, may I make one submission, my lord? Yes. 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 Hmm. Yes. My lord, what I was thinking, my lord. In fact, we are filing it on Monday. On Monday, we'll file before the Guwahati DRT. Whether Guwahati DRT presiding officer or Siliguri, until they take up, my lord, status quo as on today.
No, there is no need to.
No
go
need to
Calcutta.
mention.
There is no need to go to Calcutta or Siliguri.
Well,
The filing will be here, man. So it's only VC. Mention also, there is no separate mentioning to go to Siliguri or Calcutta. Everything will be done from here.
No, what I
The
understand, my
registered
lord,
DRT Guwahati.
what I understand, no, no. So, my lord, what I was proposing, my lord, subject to what your lordship may say, we'll file by Monday before the DRT Guwahati. My lord, whether it is DRT presiding officer of Siliguri or Guwahati, till he takes up considers our application, status quo to be maintained. That's all, my lord.
Since the main matter, the other matter which is filed by.
Fixed on 15.
Is on 15.
Until that day.
To that, but only that, that.
Yes, till
should be a
15, my
restrictive
lord.
order, man.
All right, right. Other matter is fixed on 15. 15. Main matter. Good, yeah. My lord, main matter is fixed on 15. So till 15, my lord, that's all.
As far as status quo is concerned, only regarding physical position, my lord, because there is.
Yes, physical position.
other
Physical
there
position.
was
Yes,
there
yes.
in the surface.
Mr. K. Chaudhary, Reliance Senior Counsel.
Yes.
Assisted by Mr. P. Sharma, Learned Counsel for the petitioner. Also heard Mr. U.K. Goswami, Learned CCC, appearing for respondent number 1. And
Only one.
and Mr. A. Ganguly, Learned Counsel, who's instructed to appear for respondent numbers 2 and 3. Stop. Next, para, in view of the order which is proposed to be passed. Acha, Co-District Commissioner is the government. Who will be there for the government?
Name is party.
Huh?
I name this respondent who is party.
You will be for 4.
I
am for 1.
But who is the government advocate?
By name it is made party.
Oh, acha. Okay. In view of the order which is proposed to be passed, issuance of notice on respondent number 4 is dispensed with. Next para. The Learned Senior Counsel for the petition projects that the petitioner proposes to challenge the steps taken by the respondent numbers 2 and 3 under the SURFACE Act before the Jurisdictional Debts Recovery Tribunal at Guwahati. However, he is instructed that the presiding officer is on leave till 14/12/2025, and there is no likelihood of the matter being taken up before that. Accordingly, expressing urgency in the matter, the present writ petition has been filed under Article 226 of the Constitution of India to assail the final intimation come notice dated 28/11/2025 and actions consequential thereto. Next paragraph. The learned counsel appearing for the respondent numbers 2 and 3 has opposed the prayer made in the writ petition and has also questioned the maintainability of the writ petition on the ground that as per the standing order bearing, this is the order, separate F number so and so, dated 19/2/2025, issued by the Registrar, Debts Recovery Appellate Tribunal, Kolkata, in the absence of the presiding officer of Debts Recovery Tribunal, Guwahati, the matter can be taken up. The urgent cases of urgent nature can be taken up by Debts Recovery Tribunal, Siliguri, and in the absence of a presiding officer at Siliguri, the Debts Recovery Tribunal Roman 2, Kolkata, is also empowered to take up urgent applications. He further submits that the application has to be filed before the Debts Recovery Tribunal at Guwahati, and thereafter the urgent applications can be taken up by the presiding officer of such Debts Recovery Tribunal, is empowered by the said office order dated 19/2/2025. Next para. At this juncture, the learned senior counsel for the petitioner has submitted that there are connected matter which is that connected matter or this IA. This
Same
connected
essay,
matter being essay number 161 of 2025 filed before the Debts Recovery Tribunal, Guwahati by a co-borrower. The matter is fixed on 15/12/2025. Stop. In the Mr. Sorry, in copy filed before us at page 44, the date is 15, and by the what do you call the nature of photocopy made in my sister's copy, it appears to be 16.
15. The date is 15. I was there.
No, that's okay, but Mr. Chaudhary will know it.
Right away.
Eh?
15.
Yes, always take care, because if we are in dispute, then you will be the sufferer.
So sorry, I apologize, my lord.
No, it's okay.
কেতিয়াবা হৈ যায় আৰু উপায়তো নাই।
Please, before this did I say 15/12? It's not 15. Next. He has further submitted that as per his instructions, the petitioner proposes to file her application before the Debts Recovery Tribunal, Guwahati, on 8/12/2025. Next. Circumstances. And in view of the office order dated 19/2/2025, referred herein before, the court is of the considered opinion that ends of justice would be met to allow the applicant to move the jurisdictional debt recovery tribunal. And in the event any urgency is expressed, comma, the presiding officer who is empowered to take up the matter may consider the prayer for take up the case as an urgent matter. Full stop. Accordingly, comma, it is provided that till 15/12/2025, or the date fixed for date fixed by the Debt Recovery Tribunal, comma, Guwahati for taking up SA number 161 of 2025, comma, the with regard to the property where security interest is created, status quo as regards position. As regards position in respect of the security assets created shall not be disturbed. Full stop. This interim order shall have by effects of time on 15/12/2025. With the observations and the interim order is indicated above. The requisition stands closed without examining the matter on merit. With liberty to the petitioner to move the jurisdictional tribunal as in a manner as she may be so advised.
Item 21 for admission.
Ready করো। শর্মা আচ্ছা নেক্সট উইক করবা হ্যাঁ নেক্সট উইক করি In this case, my lord, as per inquiry report, 1166 to 1971, my lord. And my lord, but the tribunal declared the petitioner of post 1971, my lord. I mean, matter may be adjourned for the day, my lord, Friday or next week, any date, my lord. Earlier this matter was heard a long time.
No, no, here we have a standard rule. If you want to rely on your previous argument, we know what you have done.
And my letter, Friday then.
We close it and we'll pass orders.
And my learned friend
We
would
have-
not object.
We have very intelligent, artificially intelligent walls. They tell us everything. In the last case, we demonstrated that.
Hmm. So, final?
Because your only argument made before the other bench was to the effect that the tribunals cannot assume jurisdiction when reference is not made.
Yes, yes.
That was the
Yes.
argument.
Confined, I'm also confined, my lord.
It's
And
okay.
my simple, my lord, I allowed to register the name.
Okay. Friday you want to do.
Friday, my lord. Friday or next week, my lord, any date, my lord.
Next week is very difficult again because only 1 week left.
Yes.
You are under immense pressure.
In a hearing day, Lord.
And maybe hearing day, my lord.
You-
It will be better, my lord.
Okay, 9. No, sorry. Okay, both sides are represented on the prayer made by Land Council for the petitioner. List on 9, 12, 2025, please.
Bless.
Item 22.
ಈ report. ಈ report ಅನ್ನು ಗೊತ್ತಿಲ್ಲ. report ಅನ್ನು ಗೊತ್ತಿಲ್ಲ. I think last order 25/3. ಈ report. medical কথা বলেছি। medical
Because my lord, the proceeding, my lord, he is my lord psychiatric patient, my lord, and suffering from my lord schizophrenia as per report. Therefore, my lord, this honorable court, my lord, directed to examine him before the medical board. By order, first order, my lord, 25/1/2019. No, medical report was also there, my lord.
Except tribunal, as per the tribunal.
No, that prayer was not there, my lord. Therefore, my lord, this honorable court take cognizance, my lord. Lordship.
Examine করা ছিল পুরো ট্রাইব্যুনালে ট্রাইব্যুনাল একটা এক্সামিন করা ছিল
Where?
বলেছে
Tribunal order মতো is 50. No, my lord, we have made prayer, my lord, there also, my lord. Page 50, my lord, is the report before the Honest Tribunal, my lord. Record action. Petition the petition. Medical. Okay. No, my lord, today.
for the purpose of defending or contesting a suit or any proceeding, there is no provision by virtue of which a court can send a person for mental evaluation. Look at this act. You can find it from the index. It doesn't say so. Now come to section 3, subsection 2, 3(2). No person or authority shall classify a person as a person with mental illness except for the purpose of directly relating to the treatment of the mental illness or in other matters as covered under this act or any other law for the time being in force. So therefore, you don't have a capacity to contest the proceeding is not a ground under the Mental Health Care Act for an exemption. That's one. Second is that the purpose would only be, because you see, it happens every day. I'm just making the tone lighter. You see, I pass an order against you, go out and say, the person who heard was not mentally good. Correct. You may not say it, but somebody may say it. But that doesn't make anybody entitled to be sent to mental examination. Just because 10 people get an opinion that this man is mentally unsound will not empower any authority. It's not a non-obstante clause. It says no person or authority shall classify a person as a person with mental illness. Therefore, how will I send somebody for mental examination? The order which was passed by the court has to be in ignorance of this law. It will not be binding on this bench, even if it is by the coordinate bench. Because you see,
Matter is covered.
a person can give evidence. Even a lunatic, that's the word used here. A lunatic also can give evidence when he's not in that condition. So the law doesn't suppose that a person is mentally ill for all times to come.
No. Always there is chance.
No, we don't know. I'm not a medically sound person, but sorry, a medically educated person. Medically sound I am, but medically educated I am not. So you see, that part is something which only somebody can assess only for the purpose of treatment. The reason is because you have to give a appropriate dosage of medicine. For that purpose, he is evaluated and then sent for the purpose of medical treatment. No other purpose. So therefore, this question would not have arisen. It's just not there. You can examine, we'll take it up on Monday.
Lordship, I may be given some time alert so that.
It's just not there.
Lordship.
In the earlier Mental Health Care Act, it was Health Act, it was there. 1987. Now it's not there. It has been removed. Mr. R. Anil and counsel for the, you see both sides are represented. Then you say, Mr. R. Anil and counsel for the petitioner has submitted that that as per the projection made in this writ petition, the petitioner, who is the proceedee, in FT case number 499 of 2017, pending before the court of pending before the Foreigners Tribunal number 2, Kamrup Metro, Guwahati, is allegedly not in good state of mental health. And therefore, an application was moved before the before the said learned tribunal for examining another person as DW3. Full stop. The said prayer was rejected by order dated 11/1/2019. Please correct me if I'm wrong in facts. 11/19, which is assailed in the present writ petition. Next one. The court is conscious of the fact that pursuant to the earlier orders passed in this writ petition, the mental status examination of the petitioner was conducted full stop. However, it has come to the notice of the court that under section 3 within bracket 2 of the Mental Healthcare Act, 2017, no person or authority is empowered to classify a person as a person with mental illness, except for purposes directly relating to the treatment of the mental illness or in other matters as covered under this act or any other law for the timing in force. Full stop. Next, under such circumstances, and in view of the non-obstante clause contained in section 3 within bracket 2 of the Mental Healthcare Act, 2017, the court query is as to whether for the purpose of examining a person as DW3, it is permissible to have the mental health assessment of the petitioner. And stop. Next paragraph. In view of the court query, the learned counsel for the petitioner seeks some time to respond. Stop accordingly. Next paragraph. List the matter on 8/12/2025.
Tell him to call.
Item 23,
Yeah, please, Lordship.
Yes. So. Back. Yes.
Yes, my lord. The discrepancy of the age and names. And as per in Annexer 1, as per registration certificate, Annexer Sachindra Ratna is the son of Pariksit. At the time of Sachindra was living temporarily in Panigaon, Nagaon. Then Sachindra Ratna shifted to village Garjaipam, where the petitioner, her sister and two brothers were born. And petitioner and married to the Gopalnath village, Dumaihagi, where is still live there. In the draft consolidation listed in Annexure 3, her name is also mentioned as daughter of Sachindra Devnath. And they have the 75 documents also. But age is difference in the two documents.
You see, your case is that by virtue of that migration certificate dated 5/11/57.
Yes, ma'am. Annexure.
Correct.
Yes.
With this certificate, you came here. Now, this certificate apparently does not contain your name.
Yes, ma'am. My father's name is James.
Yes. And now you have to show that you are covered by the provision of this 6A
Yes.
3B.
6A, yes.
That is the requirement you have to satisfy.
Yes.
That is the only query.
Yes, ma'am.
That we think you have failed. The tribunal has recorded that you have failed to show that you are continuously staying in the country post 25/3/1971. Because at the age of 38, your name was first entered in the electoral roll. And there's no other document to show that you are continuously residing in the country between 25/3/1971 to
75.
the till your first name was entered.
1975.
Whatever that much I will not remember.
What is this additional affidavit for?
Disturbance of the name. Just be clarified that by the affidavit. His name was mentioned in 75 is Sosi, son of Pariksit. This was clarified this affidavit also.
Yes. Yes.
And another is there, I was paid for submitted a death certificate also. I was already before the honorable court, already I was paid for filing the death certificate. But
Who has died?
it's not, so since the date now. Honorable court already ordered us to produce the documents 20 to 19.
Capital is. इसको पहले इसके बाद बहुत डिफाइन करेगा तो पता करेगा
Assuming that we accept this document, how does it help you? It merely connects to your father,
Yes, ma'am.
saying that he is the person who was earlier residing in the
There's
Panigaon in Nagaon town.
Yeah.
And he has shifted his residence to Geraji Palm. Gerzia Palm.
Gajapam.
At, in Nagaon district,
Yeah.
correct? But still your connection with your father is not established. Then
Only Gabura and his father was examined. And Gabura certificate is there. He was already mentioned as he is the daughter of
that
the
has been
assistant.
rejected by the tribunal.
PW to exhibit 1.
Come to this. So somewhere it is stated that he did not say from where he has come or something like that. But Mr. Sharma, you have to assist us by giving us, providing us information. You see, please come to page 7. Page 7 is a registration certificate issued by the election officer. Yes. Now, it shows that an election officer is competent to enter the, to register a person under Section 51AD of the Citizenship Act. This is normally by the FRRO. Yes. Then what is this document? If you don't assist us, we can't do anything. No. But you see, that is a question for the for Mr. Sharma. But please come to page 18. Last line of this page. In cross-examination, this witness testified that except for the voters list of 1990, she has not furnished any other voters list containing the name of her father. So therefore, your projection that in 1975 or any other year, your father exercised the right of franchise.
In 1975, his name is mentioned as Sosi, but house number and Gaon is the same. House number is 93, and another is in 90 position, house number is 93. And Sochinjo Devnath, and here is mentioned as Sosi. And same father's name is Poriksit Devnath, but mentioned.
You're not getting
There
it.
is a mention.
Now, you exhibited only one voters list of 1990. That is, what you call exhibit number. Exhibit number 4. So even if you accept this death certificate, how does it connect with you? Now you
I
come
think,
to next page,
yeah.
page 20. 20 is the second paragraph. It says in the middle, you have it is seen that the proceeding has stated in our evidence that her father had casted his franchise from 82 Roha LAC in the year 1975 and 1990, but she did not mention this in the written statement. So therefore, your evidence that you gave vote in 1975, your father gave vote in 1975, carries no meaning when you have not exhibited that document.
Now, next part is there. The proceeding proved the extra copy of police 1975 in respect of 82 Roha LSA as Exhibit 3. And voter list name is Sosi, son of Pariksit, and stated in father proceedings appeared in his respective age of 1938. Exhibit 4 is an extra copy of the 1990. This also exhibited documents, right?
Okay. Okay. Your name comes for the first time in 1997, along with Gopal Nath,
Yes, husband.
that is husband.
Gopal.
And before that, you have no document to connect you with your projected parents.
Except a government certificate, no latest documents is okay.
Compura certificate is exhibit number
1.
You know, is it not strange? The you have seen the evidence of OPW2, that is the Gangura. Gangura says, I have not seen his age is 28 years on 6/8/2018. So makes him, the date of birth would be 1990. He says, and your father died in the year 2012. He said that I have not seen the father of the proceedee. I do not know the name of the grandfather. I am not aware of the birthplace of the proceedee.
By the documents, he get a certificate actually.
How does it prove? I am not aware of the place of birth. He does not see your father. So how did you, what is the evidentiary value of the statement of the Gangura that A is the son of B or B is the daughter of C?
Definitely he will be not.
Then people everywhere.
But he said the documents which was in his hand. Yeah, for these documents, he issued the certificate actually from 1975 or these documents voter list.
Pardon me, we're not getting, please repeat again.
Gabra have the documents in 1975 or 19, otherwise his documents is in with him. So he,
Gabra doesn't have a document.
the Gabra
Please-
list is there already.
It doesn't. You see, because we go by 162 capital C of the Assam Land and the executive instructions under the Land and Revenue Regulations, 1886, does not assign the government any role except helping the revenue officer to collect revenue.
Yes, my lord, I know. But the
Definitely
voter
not-
list, after seeing the voter list, he issued the certificate actually. my lord.
So it means it's a hearsay evidence. It doesn't have personal knowledge. Huh? Oh, I can't do this. Okay. Today we have a positive time. There's a meeting scheduled right now. We'll take it up, continue with it tomorrow. Both sides are represented. Matter is heard in part. List of further hearing on. 4/12/2025. You take back this for the time being. They get lost here.
Tomorrow.
We're taking it up tomorrow.
Highly blessed.